and we are live now. Welcome everyone to the first litigation section, Litigating Despite COVID-19. My name is Mike Kelleher, and I am here with other members of the litigation section. With our presenters today are going to be George Wailes, who's going to give us a short introduction and discuss some of the resources available on the COVID site. Then we're going to have Mary McKelvey and Kirra Jones of Polsinelli. Going out of order. Michelle Galloway is going to come next and talk with a few tips about presenting remotely. Then Mary McKelvey and Kirra Jones are going to discuss some updates from the courts in Los Angeles and Alameda County, with a brief note about San Francisco, how they're handling it. We're then going to switch over to Marc Alexander, who's going to give us a short presentation on mediating remotely. And so I'm going to switch us now over and let, in just a second here, let me get back to the right window. Sorry about this. This requires a lot of juggling to Zoom and to, okay, so here's, okay, so now the Zoom call, and George, do you want to go ahead and get us started here?
Sure. I'm George Wailes, chair of the litigation section of the California Bar Association. You know that we were formerly with the sections of the State Bar, and I'm sure you're familiar with our publications. We also have an appellate and litigation summit, which this year will be October 9th in San Francisco. We have a core skills series for litigation skills, Trial Lawyer Hall of Fame programs. We promote diversity and access to justice through programs and outreach. And we try and keep you informed with updates on the law and procedures. I'm pleased to welcome you, as Mike just has done, to our first of our Thursday litigation despite COVID-19 discussions. And you heard that we'll have a number of presenters, but I'd like to first tell you a little bit about the resources that are available for the public, for California attorneys, and especially litigators on the CLA website. If you go to the homepage for the CLA, you'll find a series of resources right on the homepage, about midway down. There's a large homepage. You can see the large picture there, but then there are these 6 boxes, including public resources, court updates and resources, and attorney resources. And I really urge you to explore all of those, because they have amazing resources for California attorneys and especially litigators. But today we're going to focus on court updates and resources, because certainly during the shelter in place, with all the changes that have happened with each of our county courts, as well as the appellate courts, this page is an amazing resource for litigators. If you hit it, you see the court updates, starting with statewide orders and procedure changes issued by Chief Justice Kantil Sakaui and the Judicial Council. And if you scroll down, it starts with the Superior Courts listed in alphabetical order. And let's take San Francisco as an example. If you look at San Francisco's listing, there's a summary of the various rules and orders that were adopted: law in motion, complex litigation, etc. You'll note that it was updated April 14, 2 days ago. The CLA has been keeping these court pages updated within a day or two of orders. San Francisco issued an order on April 13th, and so the page was updated the next day with the April 13th order summary. You also notice that each, both on the statewide and down in each of the courts, there's a source link that you can turn to or hit to obtain the actual court orders or procedures that were adopted. So, For San Francisco, for example, you hit source origin, and you'll go directly to the San Francisco County Superior Court website, where you can see the latest general order was issued by the presiding judge on April 13, 2020. So this website has every court in California, not just the statewide orders issued by the Chief Justice and Judicial Council, not just the Superior Courts, but also the Appellate Courts and the Supreme Court. So all the different present telephonic appearances, all the different orders of the various courts are here. It's really a tremendous resource. And I urge you to use it for the 52 counties, wherever you have an appearance in California. And of course, always remember to check the litigation section's website as part of the CLA website. We have updates and information about our programs, and it's a valuable resource for you as well. Our publications are included on our website. So you can see the litigation update for last year, October last year, if you wanted to, thanks to our own Justice Moore. So stay safe and healthy during this shelter in place, and please consider volunteering for the litigation section. Join committees. We have applications out. The applications are due May 15th. Consider writing an article for one of our publications, or volunteering to do a webinar. All of that you can find on our website. You can find ways to contact us. And now on to Michelle for presentation tips.
So welcome everyone. I wanted to just share with you that one of the things that we've been doing as a litigation section is watching what is happening as litigators have to begin conducting depositions remotely and depositions by video. And we're going to be doing 2 upcoming webinars, one focused on remote advocacy, one focused on remote depositions. But today I just wanted to share briefly that we've already started to see problems that remind me that the rules that I use when I teach mock trials for elementary school and middle school apply equally to practicing lawyers. And the rules that I usually give when I'm teaching young people are 3 rules. Be safe, keep your body and your heart safe, which we hope everybody's doing during this shelter in place. The second is have fun. No point in spending time if you're not having fun. And that's actually one of the great reasons to volunteer with this organization, is the chance to have a great time with more than 9,000 lawyers across the state. And then finally, wear underwear at all times. And, it's kind of easy to understand in the kid context why that was a rule that I had, but apparently we need to remind some of the adults that we work with as well, because we actually have seen the first written letter by a judge who posted in Florida saying that they've already encountered one male attorney who arrived shirtless for his video conference with the court, and one female attorney who arrived still in her bed under the covers for a remote hearing. So a reminder that although I am not at all in favor of dress codes for lawyers, and generally do not believe we should be teaching things related to appropriate dress, apparently some people need some reminders a few weeks in that your daytime pajamas are not enough for a hearing with your judge. Similarly, although we all love seeing everyone's pets, you don't want a dog barking all the way through your hearing, and a bankruptcy judge just reported that this morning had occurred in their courtroom. So as I said, we're going to be actually coming back with specific concrete tips other than wear underwear at all times to help you navigate doing depositions and hearings. You'll be able to find more information about that on our website. And now I am going to send us over to Mary and Kirra, who are going to give us some real concrete examples of what's happening here in some of our California courts.
Thank you, Michelle. Apparently the mute button is our friend, and thank you for those tips. So one of the things, as George mentioned earlier, is that there is a number of different orders coming out from different jurisdictions. And so there is no consistency about what's happening from jurisdiction to jurisdiction in California. And so it's very important that we understand and have an overview of what's coming out of the different jurisdictions. So, Mike, why don't we pull up the slideshow? And what we're going to do is we'll look at LA Superior. And then after that, we'll take a very brief look at San Francisco with an eye towards diving deeper into San Francisco on a future presentation. And then Kirra will tell us a little bit about Alameda. So we'll start with what's happening with Los Angeles Superior Court. And I think it's probably a good time to really talk about what LA Superior Court encompasses. LA Superior Court has 39 courthouses and 4,600 employees. So just to get a sense of what's happening on a practical level, as of last week, 90% of the courthouse employees were working remotely. And one of the other issues is that approximately 1/3 of the total judges in LA County are over 65 years old, and so they're in a high-risk category vis-a-vis the virus. So we sort of start there with those facts, and then we move into what's actually happening at the courthouses. We have an order. The most recent order from our presiding judge, Kevin Brazil, was issued on the 14th, and he was authorized and empowered by the Chief Justice's order, which is really the Judicial Council order that came out on April the 13th. So bottom line is that his order extended the court closures. They're essentially closed except for non-essential functions through May 12th of 2020. And that's an important thing because there's not much we can do. And Judge Brazil presented via a Zoom presentation last week on Friday that he anticipated that the LA Superior Courts would be closed for all but non-essential functions through June 22nd. He explained that there was two ways that he could do this. He asked the Chief Justice to extend a one-time order extending the closure all the way to June 22nd. And if that wasn't possible, then what his plan B was to issue orders incrementally that would get us to the June 22nd date. And we can see from his order of Friday that it's going to be the latter that's going to be happening here. He extended it through 5/12, but bottom line, we absolutely expect for this closure to be extended through June 22nd. Now, it hasn't happened yet, and as we all know, this is a very fluid situation, but Judge Brazil did state that he would be very surprised if it was other than this. And so on June 22nd, the courts are expected in LA to be fully functional or fully operational, subject to some new social distancing protocols. And so bottom line, no trials in any disciplines in Los Angeles County before June 22nd. No bench trials, no jury trials. So what is happening there? There are certain functions, things that you would probably anticipate, temporary restraining orders, ex partes. There are essential functions, and I'm not going to go through them all now, but what we have is we have embedded in the PowerPoint some links so that you can find out exactly what those essential functions are. And as George showed us earlier, there is a page on the California Lawyers Association page that will link to all of the orders. And the status of the courts right now is essentially a compilation of the orders of the Chief Justice and the presiding judge over time. So that's where we are right now with respect to the status. Going back to the status of the trial dates, folks have asked, well, what happens to my trial date if I have a trial date before June 22nd? And what's happening during this emergency period is we've been informed that the courts will vacate the trial date and reset to a date after June 22nd. Also, we were told that by Judge Brazil that the pretrial deadlines will track the new trial date, which is obviously important. As your trial date comes up, you want to know if the pretrial deadlines are going to track the new date as well. So now we're going to, as a practical matter, we're going to have all of these cases now set for trial, extended to sometime after June 22nd. And so what it looks like is going to happen then is the court will evaluate all of the trial dates that are in front of it, each different courthouse, and they'll have to prioritize. The prioritization will happen as follows: the unlawful detainer cases and the preference cases under CCP 36 will have preference. They will be first, and then it's likely that personal injury cases will come second, and then the wrongful death cases after that. So there will be further, we can anticipate further continuances. And according to Judge Brazil, as a practical matter, we won't see civil jury trials likely to restart in LA County until late August, early September of this year. And of course, the exception to that would be the unlawful detainer cases and the preference cases. Those are anticipated to start a little bit earlier. With respect to law and motion, there's no, law and motion is not going forward on a remote basis, as most of the courthouses, the courtrooms are mostly closed. Spring Street, for example, is closed completely just because they don't have the resources to stay open. As of I think as of Friday, the 10th, the court was not allowing reservations for future law and motion matters, but Judge Brazil told us that that may change as we get closer to the 6/22 ramp-up date. So one of the things that has been asked about is the filing deadlines, and so we're also told that the emergency closure will create what will satisfy a good cause for extension of most deadlines and for law and motion matters. So let's go to the next slide. So we've also learned from Judge Brazil's recent order too that one of the first orders deemed March 17th through the 19th as considered court holidays for the purposes of computing CCP 12 and 12A, which is computing the number of days to file a motion, the time that's required. Now, in addition to that, April 17th through May 12th inclusive are also considered holidays for the purposes of CCP 12 and 12A. And that can also be found in the latest order, the 414 order from Judge Brazil. People have also asked about tolling provisions, and specifically the statute of limitations. And on April 5th, there were a series of emergency orders issued by the Judicial Council. And order number 9 told the statute of limitations for civil causes of action. It provides for the tolling of the statute of limitations beginning on April the 6th. And so we'll want to keep our eyes on what's happening with that too. And there will be probably further tolling provisions put in place through these orders that, like I said, keep coming out incrementally. Important to note that the time for 170.6 challenges to a judicial officer are not extended during the emergency period, and that was specifically addressed by Judge Brazil in his address. Also, this latest order from LA, from Judge Brazil, again, our presiding judge ordered that all parties who use e-filing to accept electronics, who use e-filing must accept electronic service, except where personal service specifically required by law or where the party is representing themselves or in pro per. In other words, parties cannot now, if they use e-filing, they can't say, no, sorry, I won't accept e-service. So they must do that if they're accepting electronic service. I'm sorry, if they're using e-filing. So those are not all of the rules. There are a number of rules that affect details of litigation in Los Angeles. Our purpose here is to hit the highlights and to point you to where you can find additional resources on all of these issues. So there's a very, very helpful frequently asked questions that was put out by PSC, and there we have a link to that on the PowerPoint slide. There's also a link to the COVID-19 news and resources webpage. And so again, and then George mentioned the CLA page. We're getting orders like every other day, one way or another. So it really is an evolving situation, and it takes staying on top of this almost on a daily basis to really learn what's going on. But again, just to recap, it looks like LA Superior Court will be the overall plan is to keep everything pretty much running on an almost closed down basis, except for emergency types of functions, until June 22nd. And so from what we can see right now, that looks like the plan for LA. Let's hit briefly on San Francisco before I turn it over to Kirra to tell us a little bit about Alameda. We just know that San Francisco is operating on an extremely limited basis right now. And more specifically, San Francisco is operating on an extremely limited basis. And their rule is that absent an essential quote unquote request, regular filings, discovery, law in motion will only be accepted after May 4th. And so what that means is none of that is being accepted right now. It seems pretty likely that this date will be extended. Another rule that came out of San Francisco, emergency order dated April 13th, says that all trials through June 1st are vacated, and they will be assigned new trial dates 60 days from the vacated trial date. And we will have this PowerPoint made available, and it will be posted, and you can post on the links and get a little bit more information about that. And again, we'll have a future presentation, a live webcast that will dive a little deeper into San Francisco. We just wanted to let you know. There it is. That looks great, Mike. We just wanted to let you know what the status is right now. Again, bottom line, no filings except emergency or essential requests until after May 4th. And again, likely that will be continued. So I'll pass it to Kirra now to tell us a little bit about Alameda County.
Thank you, Mary. As Mary said earlier in the discussion, every court is dealing with the closures and dealing with this emergency period differently. And Alameda is no different. Alameda is a perfect example of that. First, in Alameda, the court was closed in response to the Chief Justice's statewide order, and that closure is extending until May 3rd, 2020. And in Alameda, the closure and the emergency period itself has meant some big changes to practice in Alameda County. The first big change has been that there will be no filings at all accepted by the court unless they fall into certain emergency categories. And the court issued last Friday Emergency Order 1.8A, which enumerated those certain categories that fall under the emergency period that are actually considered emergency filings by the court and will be accepted. So I've included a link to that emergency local rule on the slide again to so you can click on it and see what those categories specifically are. But things that fall under the rule are TROs, emergency motions, ex partes, and things like that. But bear in mind when filing in Alameda County that the filings actually do need to be emergency filings, as no routine motions are going to be considered by the court right now, and for the rest of the closure period. Also, in relation to those filings, they're going to need to be done via fax filing. So if you're like me and have not used a fax machine for a while, you're going to need to figure out the logistics of that before proceeding with filings during the emergency period. At the close of March, Alameda County did shut down filing completely, and they are phasing it back in with the resumption of the fax filing. So that's the only filing method that's available or accepted by the court right now. The second big change in Alameda County, which kind of goes hand in hand with the no new filings, is no new motions will be permitted by the court. No motions to compel, no motions for protective order are going to be accepted by the court. The exception to that is that oppositions and replies to motions that were filed before the start of the emergency period, so before March 17th, they will be permitted. So if you have an opposition or a reply that comes due during the emergency period and it's in response to a motion filed before the emergency period, then that will be permitted by the court and can be filed, again, via fax. The third big change is that no new complaints are going to be accepted by the court during the emergency period. So the big question that we've kind of been confronted with is that, what do we do about depositions or evidence that needs to be preserved right now before a new complaint can be filed? Well, the court has made an exception and is accepting ex parte applications for the perpetuation of testimony or evidence preservation before filing. So that's some relief that's been offered by the court in consideration of those specific circumstances. Some other things to note in Alameda County, informal discovery conferences and also telephonic and video hearings will be held remotely via telephone and video, and those will be held starting April 20th, 2020. So starting on Monday, those will begin to be phased in on a limited basis. With respect to trial dates, which is another huge concern, the Chief Justice, as we know, suspended all jury trials for 60 days from their original trial date. And Alameda has made it clear that no trials whatsoever will go forward during this emergency period, so until after May 3rd, 2020. This is likely to be extended. One of the judges in Alameda County, Judge Lee, at the close of March, held an informal scheduling conference where she indicated that no jury trials would proceed, even in preference matters, until late May. And that was again at the end of March that she said that. So that is probably going to be pushed out further under some of the recent guidance that we've all seen. So again, we do have a link to both Emergency Local Rule 1.8a and to the Alameda County Superior Court COVID-19 webpage on this PowerPoint slide so that folks can see some of the more recent guidance that gets updated, like Mary said, every day, every other day. And so you can go ahead and bookmark those pages if you have cases pending in Alameda County to get the more recent information. But as of right now, that's the state of things in Alameda County.
Thanks, Kirra.
Thanks, Kirra. Go ahead.
So the first slide is from the Library of Congress, and it shows precautions taken in Seattle, Washington during the Spanish influenza epidemic of 1918 to 1919. And no one was allowed to ride on streetcars without wearing a mask. 260,000 of these were made by the Seattle chapter of the Red Cross with 120 workers in 3 days. So our country has been here before, and this too shall pass. Next slide. My topic is video conference mediations during the COVID-19 public health crisis. And I'm the chair of the ADR committee of the California Lawyers Association litigation section. And I last held a in-person mediation on the first week, during the first week of March. And since then, I have mediated by video conference. Cases can be resolved by social distancing with video conference mediations. And in fact, I've found that there's some advantages to video conference mediations. First of all, it saves everyone money. It means less travel, and it means less time. And we get a lot of information through the human face, and we're all used to looking at screens. So proceeding by a video conference provides a lot more information than a telephone call or an exchange of email. And finally, one thing about video conferencing is that it forces people to focus more on their interests rather than their emotions. And that's the direct result of the social distancing. Confidentiality turns out to be the most common concern that attorneys and parties have about video conference mediations. And the most popular platform, which is Zoom, has addressed that concern in several ways. And other platforms are also addressing the confidentiality concern. First of all, if you do a Zoom video conference, the host requires a password, which prevents people from being interlopers. The host can create a virtual waiting room, which means that people who enter the conversation are put first into the waiting room, and the host decides who doesn't enter the waiting room. And thirdly, Zoom and similar platforms create breakout rooms which allow the mediator to separately caucus with the sides, and the separate caucusing preserves confidentiality, and it's much like a person-to-person mediation, except you're using video conferencing technology. The United States Central District has its rules, video mediation, and effective March 13 and until further notice, mediators at their discretion may mediate by video conference or telephone. This is the change from the district court's previous rule. Parties' appearance could be excused in the mediator's discretion if the party was outside the central district. And now that's no longer a requirement for doing a video conference or a telephone conference. So how does the system work? Every week, the administrator of the program, Jenna Cummings, distributes a list of cases that require mediation. The list goes to the panel mediators, and the list appears on a platform called Sign Up Genius. And within minutes of circulation, every one of the cases is accounted for and taken by a mediator. And the mediators who are mediating during the coronavirus crisis are going to be using video conference if they are to avoid meeting in person. Let me give you a state court example, because I practice also in Orange County, where I'm on the Orange County Superior Courts mediation panel. That court has a civil mediators list, and you can find the list by simply Googling Orange County Superior Court panel listings, or if you prefer, you can go straight to the court website and check out their ADR program. And if you engage a mediator from that list, that mediator can conduct a mediation during the coronavirus crisis by means of video conferencing. Now, we have a separate program where temporary judges handle mandatory settlement conferences. And to my knowledge, that program has been temporarily shut down. And it's my hope that one day, just as we've all become familiar with court call, we'll become more familiar with video conferences, and perhaps temporary judges one day will be able to handle mandatory settlement conferences through video conferencing. But we're not there yet. There are a few resources that I found very helpful for people who want to resort to video conference mediations. First of all, a mediator named Simon Bohm has created 20+ slides to familiarize one with how Zoom works. And you can find those slides at www.odrzoom.com. Second, each of the major platforms, whether it's Zoom, Ring Central Meetings, Legaler, etc., has tutorials, and the tutorials are very helpful. Third, you can take a look at YouTube videos, and there are quite a few YouTube videos that give you information about how to video conference. And finally, if you want something in writing, you can also Google video conference mediations for additional information and discover that the technology is not entirely new, because people have been writing about it since at least 2004. Take care and stay safe and stay healthy. And if you want to resolve a case while the courts are shuttered, consider using video conference mediation. That is the end of my presentation.
Thank you, Marc, and thank you to all our presenters today. And thank you to our audience for tuning in, and we apologize for the technical difficulties. We are figuring things out as we go, like many of us are now. So please stay safe and tune in next week for our next session. Thanks very much.